Okay, so today we'll talk about the case of Dolores L. Hacbang versus Attorney Basilio H. Olo. Right, so in this petition for review, certiorari seeks to reverse the decision, reverse the October 13, 2009 decision and the 21st January 2010 resolution of the Court of Appeals. So it seeks to reverse the decision of the Court of Appeals, since the Court of Appeals affirmed the decision of the Regional Trial Court of Quezon City, dismissal of the petitioner's complaint in civil case number Q9936660 for lack of cause of action. So take note na lang that the reason for the dismissal is for the lack of cause of action. So CA affirmed RTC's decision. Okay, and it seeks to reverse it. Okay, in April 3, 1937, Bishop Sofronio Hacbang. Bishop Sofronio died having several properties left behind. Among these is Lot 8A, Subdivision Plan PSD 6227, located at España Street, San Juan, Rizal, covered by transfer certificate title TCT number 19896-22764. The subject lot. Bishop Sofronio was survived by his parents, Basilio Maria Hacbang, and his siblings. And si Bishop Sofronio have his parents, Basilio Maria Hacbang, and his siblings, Perfecto, Joaquin, Lucia, Teresita, and Dolores Hacbang. And petitioners Dolores L. Hacbang is the grandchild of Perfecto, while petitioner Bernardo Hacbang is the son of Dick Joaquin. So the respondent Basilio is the son of Dolores. So here we try to see, Bishop Sofronio is survived by his parents. So he has parents on the other side. We have Basilio and Maria. So they are still alive. And he also have, this side is his parents, and this sides are his siblings. So let's write it down. Siblings is Perfecto Hacbang. Siblings are the following. We have Perfecto, then we have Joaquin, and we have Joaquin, Lucia, and then we have Teresita, so Dolores here is already the grandchild of Perfecto. So this is Dolores. And then, it's the grandchild of Perfecto. He is a grandchild. Okay, so we have here, Dolores is the grandchild. Okay, and then here is the grandchild of Perfecto, while petitioner Bernardo is a son of Joaquin. So Joaquin, here Bernardo is the son. This one is grandchild. Alright. So take note of all these concepts. They are grandchild, and this is a son. So basically, Perfecto, Joaquin, Lucia, and Teresita are all siblings of Bishop Sofronio. Okay, and the respondent Basilio Alo is the son of Dolores. So if you look at here, Dolores is already the grandchild of Perfecto, and Dolores also has a grandson, a son. So he has a son in the name of Basilio Alo. Right. So Bishop Sofronio left a Bishop Sofronio left a will denominated as Ultima Voluntad y Testamento. He left one half. So what he did was he left one half of his properties, and the other half, including the subject, to his sister Dolores. So here, Bishop Sofronio left a will, and he left one half of his properties to his parents. So one half to his parents, and another one half, and devised the other one half, including the subject lot, to his sister Dolores. So Dolores is the receiver. The pertinent portions of his will read: Fourth, by this presence I give, name, declare, and institute as my heirs my parents Basilio Hacbang and Maria Garboni di Hacbang at one half of all my properties, whether real, personal, or mixed, whatever place they may be found, whether they are acquired before or after the execution of this testament, including the properties that at the time of my death I may have the power to dispose by will, and which properties consist of the following. We have 50% of the shares of stock I own in Samar Navigation Corporation Incorporated, a parcel of land with Camarin situated in the municipality of Caraga, province of Leyte, and a parcel of land in Barrio Pinamupuan, municipality of Kaupuukan, province of Leyte, and a parcel of land with house and planted to coconuts in Barrio Sorsogon, municipality of Santa Margarita, province of Samar. Fifth, the other remaining half, of the properties, wherever they may be located by this persons, I give and cede in my hand over to my sister Dolores Hacbang, which properties are particularly described as follows. 50% of my stockholdings is Summer Navigation Corporation Incorporated, a piece of land with one house where the Botica San Antonio is located, and in the municipality of Calbayog, province of Samar, a piece of land with house in Asidillo Street, municipality of Calbayog and the province of Samar, and a piece of land with one Camarin in the barrio of Sorsogon, municipality of Santa Margarita, province of Samar, and 6 parcels of land located in New Manila, municipality of San Juan, province of Rizal, in 7th Street, described as follows. Block 7, Lot 16, 18, 20, and 22 in the 3rd Street, Block 3, Lots 4 and 6. A piece of land situated in España Street, municipality of San Juan del Monte in the province of Rizal, marked as Lot 8, Block 17, 1,403 square meters in area. So in April 16, 1937, a petition for the probate of Bishop Sopronio's will and the settlement of his estate was filed before them, the Court of First Instance. The petition was docketed as SP Proc number 51199. In May 21, 1937, the CFI, or the Court of First Instance, admitted Bishop Sopronio's will to probate. So, they already admitted it to probate. The records are bare with respect to what happened next. They show, however, that CFI ordered the proceedings to be archived on November 1957. So, on November 24, 1971, the Registry of Deeds of Quezon City appears to have issued TCT number 169342 over the subject line in the name of respondent Basilio H. Alo. TCT number 169342 cancelled 117322T-500. However, this court determined the circumstances surrounding the issuance of TCT number 169342 or the relationship between TCT number 11732 T-500 and TCT number 19896227644. Why? Due to the inadequacy of the documents on record. So on March 17, 1975, Dolores Hacbang Alo moved to revive the settlement proceedings because the CFI have not yet completed the adjudicating the properties. On May 23, 1975, the CFI denied the motion for revival because the order to archive had long become final and executory. Again, May 23, 1975, the CFI denied the motion for revival because the order to archive had long become a final and executory. On February 1, 1999, petitioners Dolores L. Hacbang and Bernardo. So remember that Dolores L. Hacbang and Bernardo here are the son of Joaquin and Perfecto. Here, Basilio Alo is the son of Dolores. Okay, so again, on March 17, on May 23, 1975, okay, on February 1, 1999, okay, Dolores L. Hacbang and Bernardo filed a petition to cancel TCT number 169342 on the ground that it was fraudulently secured. In support of their allegations, they submitted March 5, 1997 investigation report of Land Transportation Authority, Land Registration Authority, Investigator Rodrigo Del Rosario. The report concluded that TCT number 117322 was doubtful in terms of authenticity and was never derived from TCT number 117322 nor issued by the Registry of Deeds of Quezon City on September 24, 1971 at 2:30 p.m. In his answer dated August 18, 1999, Basilio denied all allegations of irregularity and wrongdoing. So, Basilio here, which is the son of Dolores, denied all these allegations. of irregularity and wrongdoing. He also moved to dismiss the petition because the petitioners were neither heirs nor devices of Bishop Sopronio. So notice that here, Dolores L. Hacbang, according to him, were not heirs, no, nor devices of Bishop Sopronio, and had no legal interest in the subject area. That's according to Basilio. On January 7, 2003, the RTC dismissed the petition because the petitioners had no right to prosecute the case on the subject area. The RTC noted that Bishop Sopronio's will had already been admitted into probate in 1937. Thus, the intrinsic validity of the will is no longer in question. Though the settlement proceedings were archived, Bishop Sopronio already designated his heirs, and Bishop Sopronio's parents were compulsory heirs entitled to half of his estate, while the respondent's mother, Dolores Hacbang, was devised the remaining half. Thus, the petitioners are neither compulsory nor testamentary heirs and not real parties of interest. The petitioners moved for reconsideration while the RTC denied on August 19, 2003. The petitioners appealed to the Court of Appeals, arguing that Bishop Sopronio's will did not validly transfer the subject property to Dolores Hacbang Alo, and the probate of his will is not conclusive as to the validity of its intrinsic provisions, and only a final decree of distribution of the estate vests title and the properties from the estate of the distributees. The appeal was docketed as CAGR number 83137. So the petitioners here appeal to the CA. They argue that, Bishop Sopronio's will did not validly transfer the project property to Dolores Hacbang Alo, and the probate of the will is not conclusive as to the validity of its intrinsic provisions, and only a final decree of the distribution of the estate vests title the properties from the estate of the distributees. They further argue the petition of the estate should be governed by intestate succession because here, they argue the law that will govern is intestate succession because the subject property was not adjudicated and the settlement proceedings were archived and dismissed. Thus, all properties passed on to and became part of the estate of Bishop Sopronio's parents. The petitioners concluded that they had legal interest and subject lot as representatives of their ascendants and the other children of Bishop Sopronio's parents. Okay, so since that is now the case, the petitioners concluded that they had legal interest. In this appeal brief, the respondent insisted that petitioners do not have a clear legal right to maintain suit because collateral relatives, they cannot invoke the right of representation to the estate of Bishop Sopronio, and they are not real parties of interest and have no right to action over the subject lot. So, motto dismissal was because of lack of cause of action. October 13, 2009, the CA affirmed the RTC's order of dismissal, and the CA and the admission of Bishop Sopronio's will to probate precluded intestate succession unless the will was intrinsically invalid or failed to complete dispose of his estate. Contrary to the petitioner's contention, the settlement proceeding was not dismissed but archived. The will did not lose its validity merely because the proceedings were archived. So, undoubtedly, Bishop Sopronio did not die intestate. Okay, the Court of Appeals denied the petitioner's claim to a right of inheritance by representation. It held that this is now the decision of the Court of Appeals. It held that the presence of Bishop Sopronio's parents during his death excluded his brothers and sisters from being compulsory heirs. The petitioners can represent those who are not entitled to succeed. Considering that they are neither compulsory nor testamentary heirs, petitioners have no legal interest in the subject property, and the petitioners moved for reconsideration with the CA denied on January 2010, and the denial paved the way to the Supreme Court. They filed a petition for review on certiorari. Now, the petition, what is the argument here? The CA, according to them, erred when it failed to rule in the validity of TCT number 169342, and that the probate proceedings or the estate was dismissed, not archived, and that the Court of Appeals erred when it used Bishop Sopronio's will to declare that they are not real parties of interest. In his comment, the respondent maintained that the petitioners had no right over the property and moved to dismiss the present petition. So, our ruling. At the outset, this court observes that the parties and even the lower courts erroneously applied the provisions of the Civil Code to the will and the estate of Bishop Sopronio. The law enforced at the time the decedent's death determines the applicable law over the settlement of this estate. So, what is the prevailing law? So, later on, we'll find out. Now, Bishop Sopronio died in 1937. before the enactment of the Civil Code in 1949. Therefore, correct applicable laws in the settlement of his estate are the 1889 Spanish Civil Code. So we will use the Spanish Civil Code and the 1901 Civil Code of Civil Procedure. In any case, under both Spanish Code and Civil Code, successional rights are vested at the precise moment of the death of the decedent. So we will our reckoning point is the precise moment of death, no? Section 657 of the Spanish Code provides, Article 657, los derechos a la sucesión de una persona se transmiten desde el momento de su muerte. So the inheritance vests immediately upon the decedent's death without moment of interruption. The provision was later translated as adopted in Article 77 of the Civil Code of the Philippines. As the consequence of this principle, ownership over the inheritance passes to their heirs at the precise moment of death. So that is what is the meaning of that. Not at the time the heirs are declared, nor at the time of the partition, nor at the distribution of the properties. There is no interruption between the decedent's ownership and the start of their heir, legatee, or device's ownership. For intestate heirs, this means that they are immediately entitled to their hereditary shares to the estate, even though they may not be entitled to any particular properties yet. For legatees and devices granted specific properties, this means that they acquire ownership over the legacies and devices at the immediate moment without prejudice to the legitimes of compulsory heirs. Undoubtedly, Bishop Sopronio did not die intestate. No, he left a will that was probated in 1937. He left half of his properties to his parents and the remaining half to his sister Dolores Hacbang Alo. The admission of his will to probate is considered conclusive with respect to its due execution and extrinsic validity. Unfortunately, the settlement proceedings were never concluded, and the case was archived without any pronouncement as to its intrinsic validity of the will or an adjudication of the properties. Because of this, the petitioners posit the intestate succession should govern, and they maintain that the entire inheritance should have gone to the Bishop Sopronio's parents and the petitioner's ascendants. Thus, they claim to have the legal interest in the subject as representatives of the other children of Bishop Sopronio's parents. So we do not find the petitioner's argument meritorious. Article 763, no, el que tuviera herederos forzosos puede disponer por testamento, etc. No, this provision states that a person without compulsory heirs may dispose his estate either in part or is in entirety in favor of anyone capacitated to succeed him. If the testator has compulsory heirs, he can dispose of his property provided it does not impair their legitimes. Now, their provision was later translated and adopted as Article 842 of our Civil Code. Our jurisdiction accords great respect to the testator's freedom of disposition. Hence, testate succession has always been preferred over intestacy. As much as possible, the testator's will is treated and interpreted in a way that would render all of its provisions operative. Hence, there is no basis to apply the provisions of intestacy when testate succession evidently applies. Even though if the court of first instance achieved the settlement proceedings, there is no indication that it is declared any of the dispositions of the will invalid. So the records are understandably bare considering the probate proceedings were initiated as early as 1937. Nonetheless, we find no reason to doubt the intrinsic validity of the will. So Bishop was free to dispose his estate without prejudice to the legitimes of his compulsory heirs. Bishop Sopronio only compulsory heirs were his parents, and their legitime was one half of the bishop's estate. Considering that Bishop Sopronio gave his parents half of his estate, he was free to dispose the free portion of his estate in favor of his sister Dolores. Thus, this will is intrinsically valid. So, the court of first, the CFP's failure to adjudicate the specific properties is irrelevant because Bishop Sopronio did not name his heirs. He also identified the specific properties forming part of their inheritance. The disposition of this will rendered court adjudication and distribution unnecessary. So the petitioner's contention that only a final decree of distribution of estate vests title on the land and the estate in the distributees is also incorrect. Again, ownership over the inheritance vests upon his heirs, legatees, and devices immediately upon the death of the decedent. Upon the death of the decedent, the inheritance is transferred. So at the precise moment of death, the heirs become owners of the estate pro indiviso. They become absolute owners of their undivided aliquot share, but with respect to the individual properties of the estate, they become co-owners. So this co-ownership remains unpartitioned and waits for distribution. Until then, the individual heirs cannot claim any rights over specific property of the estate. This is because the heirs do not know which properties will be adjudicated to them yet. Hence, there is a need for partition before a title over the particular properties vests in the distributee or heirs. However, heirs and legatees and devices bequeath specific properties do not require court adjudication to identify which particular properties become theirs. The testator had already identified those from the very moment of his death. No title over these particular properties vests on their heir, legatee, or devicee. So in April 3, 1937, title over the subject lot passed over the respondent mother Dolores on the respondent's mother Dolores Hacbang at the exact moment of his brother's death. From that moment, and she was free to dispose the subject property as a consequence of her ownership. On the other hand, Bishop Sopronio's parents, Basilio and Maria Hacbang, never acquired the title over the subject lot, thus never become part of their estate. Clearly, petitioners who claim to represent the children of Basilio and Maria Goborni in the spouse's estate had no legal right or interest over the subject lot. Even ordinary civil action must be based on a cause of action, an act omission that violates the rights of the plaintiff. A cause of action requires the following. First, a legal right, requirements for cause of action. Okay, a legal right in favor of the plaintiff. Number two, there's a correlative duty of the defendant to respect plaintiff's right. And there is an act or omission of the defendant in violation of there is an act or omission of the defendant in violation of the plaintiff's right. Every action, so na illegal right, and there is a correlative duty of the defendant to supposedly to respect the plaintiff's right. And lastly, there is an act or omission or a defendant of the defendant in the violation of the rights of the plaintiff. So every action must also be prosecuted or defended in the same name, the real property in interest, the party who stands to be benefited or injured by the judgment. These fundamental requirements are not merely technical matters. They go into the very substance of every suit. The petitioners came to the courts praying for the annulment of the respondent's title, yet they failed to show that they are entitled even ask for such relief. They have no right over the subject lot, and respondent has no legal obligation to them in respect to subject lot. Even if we assume that the respondents fraudulently or irregularly secured their certificate of title, the bottom line is that the petitioner has no legal standing to sue for cancellation of this title. The right only belongs to the rightful owner of the subject lot. Judicial power is the duty of the court to settle actual controversies involving rights which are legally demandable and enforceable. Courts settle real legal disputes involving the rights and obligations between the parties. If either the parties is not the real party of interest, the court cannot grant relief prayed for because the party has no legal right or duty with respect to his opponent. Further litigation becomes an academic exercise in legal theory that eventually settles nothing, a waste of time that could have been spent in resolving actual justiciable controversies. Wherefore, premises considered, the petition is denied for lack of merit. Cause against the petitioner so ordered.